This episode of Legacy Curious is brought to you by Legacy Protectors. Customize insurance strategies for business owners and families who aspire to create a lasting legacy. Hello and welcome to Legacy Curious. I'm your host, David Gravelle, and today I'm so happy to welcome back Larry Parman from Parman Easterday, focusing his practice on family and business trust. He is a published author. He's the former Secretary of State and Secretary of Commerce of Oklahoma. Larry believes in helping families avoid probate and offers monthly seminars where you can attend to learn more about the pitfalls of probate and the benefits of establishing a family or business trust. I've invited Larry back on to speak directly to entrepreneurs, solopreneurs, family-owned businesses on ways for them to protect their wealth and their families with various trust structures. Let's welcome Larry and start to learn some more about family and business trusts. All right. Well, welcome, Larry, to the show again. Second appearance here. How are you today?
I'm great, David. How are you? Good to be with you.
I'm doing well. Thanks again for joining us. You are a very important part in my business education here on the channel. And I've asked you back on today to talk specifically about how trusts can work either for a family-owned business or a solopreneur or a small partnership. So let's just dive in and get you started with our first question, which is how important is it to coordinate your trust attorney, your CPA, and your financial advisor?
Well, on a scale of 1 to 10, it's about 11. So it's pretty important. And I see that overlooked a lot. Sometimes there are egos involved with all three of those parties. Everybody wants to be the quarterback, and everybody wants to control the dynamic of that relationship. That's understandable. But some way, somehow, it serves the client best if those three parties, legal advisor / lawyer, financial advisor, and CPA, can work together. Because otherwise, then each of those three parties may be going out in different directions. And that leads to confusion on the part of the owner. Sometimes the CPA is not strategic. They're merely bean counters. That's not being critical, it's just the truth. But when they are strategic, they can offer a lot of good ideas. Likewise for the lawyer, likewise for the financial advisor. So I think it's a factor that all business owners should consider. And I think the business owner should have a conversation with all three of those parties in the same room and say, hey, guys, I want you to work together. And I want the three of you to meet from time to time and talk about my situation and my issues and my problems, maybe even without me there, and then give me some feedback. So good question to ask, good reminder for all business owners. Every business owner needs all three.
Great. So next question I had for you was, give me some advice on a business owner holding their business ownership in a trust versus an LLC. And when would you decide to use either one or both?
Well, obviously, the most conventional thinking is that when you start a business, you form some kind of a corporate entity. Now, in our practice, we've not formed a regular corporation for years. Every entity that we form is an LLC. And for your listeners, an LLC can be taxed one of 4 different ways. Either individually, if it's a sole member LLC, or as a partnership, if there are 2 or more members, as an S Corp, or as a C Corp. So the default thinking is to form an LLC. Now, what's interesting about that question, though, is this whole idea of a business trust, or to say it more simply, using a trust to be the owner of the business. Now, that gets to be very interesting because there's some advantages to that. So, for example, you don't have to go through the formalities of corporate formation and so on and so forth. You typically have to get an EIN number, but you do save some money and a little bit of a headache, not too much, because there's not really that much of an ongoing administrative issue with limited liability companies. But some people who form a limited liability company assume that all they have to do is go online and complete the formation documentation at the Secretary of State's office, and it's finished. But it's not. Every LLC should have an operating agreement, and that's critically important. So by contrast to the LLC or a corporate entity, a business owner could have his business owned by a trust. They could serve as the sole trustee of that trust. They could be the sole beneficiary of that trust. And that might be an equally effective way to manage your business entity. Now, a couple of questions about that. So I'll ask the ones that you may have on your list too. The question is, well, what about in the event of a lawsuit? So this is where the structure of both the operating agreement and the trust become critical. So in all states, an operating agreement is a statutory animal created by state statute. In many states, the sole remedy, in other words, the only way that a creditor can make a claim against your interest in that LLC is through what's called a charging order. That means that the creditor, even with a judgment, cannot go inside that LLC, cannot force you to give up management, cannot make you sell assets. It does not make their judgment go away, but it tends to level the playing field between the debtor and the creditor, and hopefully leads to a better negotiation. The LLC will offer both what's called inside asset protection and outside asset protection. I'm not sure how deeply we want to go into that, but that's one of the question marks about a business trust, going back to that concept. Because if you set up a business trust and you are the sole trustee and the sole beneficiary, and that trust has certain language in it that gives you discretion to make distributions, that may not offer the asset protection that you want. There are ways that we manage that through putting other features in that trust agreement. But once those features kick into effect to afford asset protection, then you lose some control. So there's always a pro and a con. We've actually used business trust to be the general partner of partnerships in the past, and they can be very effective. So you really have to assess what the nature of the business is, what the purpose is, what your objectives are, what kind of asset protection and control you're looking for, not just when things are going well, but when things don't go well. That's what
crucial.
you want, is you want to be protected when it doesn't go well.
Right. So how does that overlap with, let's say, a family trust, and the ownership of a business trust would be owned by a family trust? Is that how that works? And when would that be appropriate for solopreneurs or small business owners?
So you can get about as complicated as you want on these ownership structures. So you can set up a trust and have a trust be the beneficiary of the trust. You can set up a revocable trust and perhaps have an irrevocable trust be the beneficiary. That might be one of the ways you can create some asset protection in a trust you might not otherwise have. So a family trust, what we typically think of as a family trust, and I think what most people think of a family trust, is the traditional revocable trust plan that a husband and wife create when they're married, or a single person creates when they're single. But that family trust is typically the foundation that identifies how assets will be transferred to your heirs in the event of your death, or how they will be managed in the event you become incapacitated. And that latter feature is very important. As people are living to an older age, the odds of incapacity increase, and having control and a method and a hierarchy of management succession becomes very important during those very tender years toward the end of life. So the family trust is typically designed to be set up to be revocable, number one. Number two, to have the party setting up the trust be in control by serving as their own trustee, naming themselves as beneficiaries while they're both alive, or one person's alive in the case of a single person, and then on to the children upon their death. Now, there's a lot of moving parts to consider in between all those points I made. But that's what we typically think of when we have a family trust. One other point, then I'll move on. And that is whether that trust should be a joint trust created by both the husband and wife together, or should there be two separate trusts, one for the husband, one for the wife? Different practitioners feel differently about that. Some of the old timers really like that two separate trust concept. We tend to prefer the joint trust. Makes it a lot easier to operate during lifetime. So I hope that touched on some of the high points there.
Yeah, that's great. Pardon the background noise here.
That's okay. I didn't hear
a second. Yeah, okay.
I didn't hear
They're doing some landscaping here, so apologies if it's coming through. Okay, so talk a bit about buy-sell agreements for partnerships and how not only useful they are, what's the purpose and the benefit to setting them up. Then I'll ask you about how insurance can help and be implemented with that. So let's just start out with, why when I recommend people to your law firm to talk about buy-sell agreements, when and where is that a good place to start?
I need to take a deep breath here because you know how in the insurance world, it's sometimes said that they've never seen a beneficiary disappointed in receiving a death benefit, despite the pain of losing a loved one. I can't tell you how many times we've had business owners who are partners come to us almost in tears because of not following the advice of having a buy-sell agreement. And the consternation, frustration, all of that can occur on the part of family members who are left behind. We've even had instances where one happened recently, where two partners, one died, there were 50-50 owners. Before the spouse of the deceased partner could even find out what was going on, because she had no authority to have access to anything, the other partner took all the money, let all the money out, transferred all the contracts to a new entity he owned 100% of. And so now what's her remedy? Only a lawsuit. And that's going to cost her six figures in legal fees, and it's going to go on for 2 or 3 years. So here's my point. There's nothing that beats preparation. This is a good time to be a Boy Scout. Be prepared. Buy-sell agreements are very important, critically important, because they identify what happens in the worst case. It identifies the value, how we're going to value this company and each partner's interest. And there's typically by some kind of an agreed upon formula and agreed upon pricing. It identifies how the buyout will occur and how that buyout will be funded. And it's always a great opportunity to fund that buyout with life insurance because it makes things so simpler and so easy. But in the event that the valuation comes in higher than the death benefit, then there can be a provision in the buy-sell agreement for payment through an installment note of the remaining balance of that value over and above the policy to the surviving family over a period of time. So again, when you have all that laid out, it just removes so much doubt, lack of trust, because that buy-sell agreement should also provide for things like access. How are my legal representatives and my family going to know what's going on in that business? They may not have any management control or authority, but if the buy-sell agreement stipulates that they'll be entitled to receive financial reports, have access, maybe even continue to be on the board, all those things that can be addressed just give us reasons why, reinforcements why buy-sell agreements between and among business owners, critically important.
Help us understand how insurance plays a role in that and where you've seen that most effectively implemented and what does it look like when it's executed?
So repeat that question again.
Yeah. How does key person insurance fold into the buy-sell agreement, and how's it best implemented? Where have you seen it most successfully used?
Well, there are a lot of business owners that are doing very well, but they're also, they go through periods where they're a little bit strapped for cash. And maybe their secured line of credit or line of credit secured by inventory and receivables uh, may not be sufficient to cover the cost they will incur if a key person either dies or leaves the company. So traditionally, what key man insurance is designed for is if you have a president, for example, or chief operating officer or CFO, chief marketing officer, chief intelligence officer, AI, head of the AI department, whatever the case may be, and they leave, well, it's going to be time consuming and expensive to replace that talent. And so what key man insurance can do is provide a death benefit in the event that person passes away, so that there is a source of liquidity that gives that business the opportunity to replace that talent. And that again can be, I don't even have to say that's important. It goes without saying how important that can be.
And how's that executed with a buy-sell agreement? If one of the partners, if they both have key person insurance on each other, and they have that language, tied into the buy-sell agreement, how's that executed upon the death of one of the partners?
Well, that could be, so those are provisions that we included into buy-sell. And those provisions then would be adopted and integrated into the to the minutes of the company, so it's official policy. So the partners, for example, might say that we have parallel tracks here. We have one track that identifies what the loss to the company is if your skill set and your talents disappear. We have another track that says if that business owner, this is now not from an employee point of view, but from a business owner point of view, if that person as a business owner passes away, there's a value to the equity ownership in the business. And here's how we're going to value your equity interest in that business. So we're going to have two valuations. You as a key employee and a loss of talent on one side, which would require separate coverage, a standalone policy, and a buy-sell agreement, which would trigger a payment of money to the family in exchange for the family returning the shares back to the company or back to the other business owner. I guess I should make the point that there are two types of funding for buy-sell agreements. There's what's called a cross-purchase agreement, in which the partners insure one another. Then there's an entity agreement where the company itself takes out the coverage, is the owner of the policy, and then it springs into effect. The death benefit gets paid to the company. Company uses that money to buy out the family, and they redeem those shares in treasury stock.
Thank you for that clarification. Okay, so let me just kind of switch tracks a bit and talk about the next generation in a trust. So the beneficiaries of a trust, what are some of the ways that your firm helps prepare them for their inheritance and the responsibility of managing that wealth that they've been, the beneficiary of?
Interesting challenge, because some clients don't want to tell children or grandchildren anything about their plan or what they have. In my view, the smarter move, if someone's in a position to and has a desire to create intergenerational wealth, then you almost have to get them involved. Now, if they're minors, probably not. But if you have an idea of creating Rockefeller, Kennedy type concepts and you want to pass wealth on generationally, well, you're going to have some understanding by the family. I think that's one of the reasons why this concept of a family office has sprung up. I know in our case, we've had instances where I've recommended and people did this. They went through what we call our family wealth counseling engagement, where I spend a full day with the client talking about their deepest concerns and their highest aspirations for their family in terms of values, meaning, wealth management, wealth maintenance, wealth preservation. And then we design a plan around that. We've actually had people set up charitable organizations, not only because they wanted to benefit a charity or charities, but because they wanted to use it as a training tool, a training environment to teach people about social responsibility, about family responsibility, about wealth management, et cetera. So I always encourage people to do that if they have any desire to think about wealth planning beyond the next generation. If all somebody cares about is, hey, upon my death, give it to my kids, well, that doesn't lead to much of that. That's not a very deep conversation. But if somebody is thinking about, okay, well, what happens if a child gets divorced? Or what happens if a child predeceases me? And what happens if that child that predeceases me has minor children and cannot inherit what they would otherwise receive? What happens if one of my children is a doctor and they're being sued at the time I die? And now is their inheritance subject to that child's creditors? Those are deeper, more meaningful conversations. So, in my view, I love the idea of intergenerational wealth thinking and planning. And there are a multitude of wonderful products that can facilitate that. So I'm not sure that's what you were getting at, but
yeah, that's it. And around here on this channel, I mean, that's one of the purposes is to prepare the next generation to be wealth stewards and not trust fund babies. We want to eliminate that whole class of citizens that just don't know what, frankly, the privilege it is to inherit family wealth and the responsibility they have to the next generation. They're just, they have to pay it forward in my mind. And that's, the purpose of this channel and what I do every day is to try and prepare not only my own family, but others for that. So thanks for that answer. And so
I have one more point about that.
Yeah, please, Larry.
So one thing that I think people don't pay enough attention to is when they think about intergenerational wealth transfer, they only think about the money. They don't think about the values and the belief systems that need to accompany that. Because a lot of times what ends up happening is the children end up using the money for purposes the parents did not like, did not believe in, and so forth. So I think the training and the teaching and the sharing about belief systems and values, that may be more important than the money. I mean, sometimes I tell people at our programs, the money you leave your children may be the least important thing you leave them.
And then that's one of our deliverables here as well, is a document that captures the family's legacy, mission, and what their intent is. And that's part of the training. I'm committed to, again, keeping that center of conversations in their annual and reviews for the family and all the beneficiaries so that it's understood, the purpose of all of this, these efforts and the structures that they're, spent time organizing. And so let's segue into, how do people take some action here? So I want to promote your monthly seminars. And as we've talked about in your last interview, people can, in the Oklahoma City area, attend them. The next one on the schedule here that I see is coming up on Tuesday, July 22nd at the Hampton Inn in Midwest City. So we'll have contact information in the description, but they can also get that virtually, right? Right, Larry?
They can go on our website and they can sign up there. They can call a hotline and register there. They can call our office at 405-843-6100. Register there. Those programs, I mean, who wants to go to a seminar? Just another seminar, right? Oh my gosh, I've got to go listen to Parman talk about death and taxes. Maybe the most important 90 minutes you'll ever spend in your life.
I concur, Larry. It was for me. It was life-changing for me, and it's one of the reasons I'm doing this channel is because of the arc that you sent me on, and I'm hoping others will experience the same thing. Just the pitfalls of probate alone is enough to get your life in order to protect your family from that, but also just the way it brings a family together to have multiple conversations like this and to give purpose to the lives you're living. And all of that, I think, is just wonderful. And it's delivered in that seminar. So again, I can't recommend it enough. And if you can't attend it live, like Larry said, there's ways to experience it virtually. And then once they've gone through that process and they feel like they're ready to meet with you and discuss specifics around getting started, what kind of documents should they make sure they have, come prepared? What other things can they do to make sure they're spending their time well when they do engage you and your firm?
We always encourage, almost require, people either come to one of our live seminars or watch one of our online webinars before they come in, because it prepares them, and it answers questions, but it triggers other questions. So when they come to one of those events, we always give them a consultation form and a map to the office and what to expect when they come in. The consultation form is very straightforward, but it asks them a few questions. It prompts their thinking. So in addition to sharing their name and address and contact information, it will lead them to a discussion about what they'd like to accomplish with their plan. And I tell people, if you can do that, that'll help us make that meeting more meaningful when you do come in, and we can get to the heart and the matter of what you'd really like your plan to accomplish a lot quicker, rather than have some, broad generic conversation that leads nowhere. And then at the end of that meeting, we always put people in a position where they can say yes, no, or maybe. And assuming we can work together and we can get on the same page and we can develop a client relationship, at which point we have them sign a simple legal services agreement. We come to an agreement on what the investment would be to create that plan. And they know that ahead of time before they ever have to say yes. So no surprises on that. They know how to budget for that, when it's going to be payable, and so forth. We typically ask for a good amount of that in the beginning, because we'll finish our work before they finish theirs. And then we finish it in 30 days. That's our promise. Fixed investment, try to turn the work in 30 days or a date or a number of days that they agree to and that they need. They might be going on vacation, might be 40 days. And then third, we're going to be sure that when they walk out our front door, they're happy, that they feel great about it, that they've touched a peace of mind that maybe they've not realized before. They've removed something from their to-do list they've been kicking down the road for years.
Right.
So
right.
that's our
Okay.
promise to them.
All right. So let's assume that all that goes to plan for our viewer, and it's 90 days down the road. When is the next time you'd suggest they start to revisit the work you've done, and how often do you get back together with your clients, and what does that look like?
We remind people that estate planning is not a one and done deal. So among the things we talk to them about as they're going through this process and reinforce at the end is to be sure, again, that all of their advisors are on the same page. If they're working with a financial advisor, coordinate our efforts. CPA, same thing. Typically, there's a lot of interface between us and the financial advisor. Financial advisors can help with change of beneficiary forms and those kind of things, and be sure that everything's coordinated with the plan the way it should be. And then in terms of keeping the plan up to date, don't put it on the shelf, let it gather dust. It doesn't need to be changed every year, but you should probably come in. We always recommend once every 3 years, or anytime sooner where there's been a big change in your life, big change in the desire about how you want your plan structured, change in the tax law, because their life changes, our opinion changes, and recommendations change. So keep it up to date. Come in every 3 years. That's a complimentary visit. We don't charge for the time. Obviously, if they want to make changes to the document that require an amendment, there would be an amendment charge to do that. But again, we come to an agreement about what that would be up front, and they can say yes or no. So, and we communicate with people regularly. This is not a transaction for us. This is the beginning of a relationship. So in the mail newsletters, electronic newsletters, and I kid people a little bit and say, you may not read all the material in the newsletter, but you'll sure like those recipes that my wife includes. They're very good.
Nice. Excellent. Okay, so we're going to wrap it up here just by reminding our audience that you're a published author. We'll have some more information in the description. Do you want to mention your book at all, Larry?
It is a great resource for people who are beginning the journey in estate planning. It's called The Straight Shooter's Guide to Estate Planning. It's available on Amazon. Come to one of our programs and you get a complimentary copy.
Oh, can't beat that. Can't beat that. Free gifts, right? Yeah.
A lawyer giving away a free
Right.
book. How about
Yeah.
that?
Yeah, and I'll tell you, my own copy has been dog-eared and underlined, and I want to encourage everyone to if you can't get to a live event, check it out online. Reach out to the firm, and if you're looking for a free book, I'm sure Larry can make that happen for the right for the right type of client. And just want to wrap up by saying thanks again, Larry, not only for my audience for your work today, but for myself and my family. Just been a wonderful resource and guide in our own journey, and that's why I've got you here, is because I just see how much value you are, and I want to share you with everyone. So thanks again for joining us, and we'll look forward to having you back on in the future.
Thank you, David. Have a great day.
All right. Well, there you have it, folks. Larry Parman from Parman Easterday helped us understand family trusts, business trusts, how to learn more, and hopefully spurred you into taking action to protect you and your family's legacy. Thanks again for watching. We'll look forward to seeing you again in the future with more interesting business-focused information and exciting guests to share their personal legacy. If you or someone from your family would like to get their legacy in order, reach out to us at legacyprotectors.life. And until then, share, like, subscribe to this channel. We'll be looking forward to engaging with you in a number of ways. Everyone has a story to tell. Let's make sure yours is shared and remembered.